Hi everyone, so we're back with chapter 2. We're going to look at the American structure of courts today. And we have our introduction as well as our learning objectives. So, classifying American courts. One way we look at American courts is by jurisdiction. So, jurisdiction is defined as the legal authority and power of a court to hear specific kinds of cases. So, jurisdiction can vary according to the offense, the seriousness of the crime, and whether the case is being heard for the first time or on appeal. So, those are different areas we're going to look at. Starting with subject matter, geographical, and hierarchy jurisdiction. Subject matter essentially is the type of cases that are legally authorized to hear. So if a misdemeanor and a preliminary hearing are processed or conducted by what we call limited jurisdiction courts. So a limited jurisdiction court is restricted to handle certain types of cases, such as probate matters or juvenile offenses. One example of a subject matter jurisdiction would be if a person burglarizes a property, the dollar value of this property stolen determines what court they would appear in. So the greater the value, the more likely the case will be heard in what we call a general jurisdiction court. So a general jurisdiction court has the power to hear a whole wide range of cases, both civil and criminal in nature. Now, a geographical court is a little different because it has the power to hear particular kinds of cases depending on the legally defined boundaries of a city, a county, and a state. It is the clearest type of jurisdiction to understand because it's obviously just based on geographical location. And then hierarchical jurisdiction is basically the difference between appellate courts and trial courts. So think of a hierarchy. So you're starting at the bottom with the trial court, and then it can be appealed to what we call an appellate court. Trial courts are fact courts because they are the forum where a judge or jury listens to particular facts presented in the case and determines whether or not the individual is guilty or liable. Sometimes they can also be sentenced in that particular court. In contrast, appellate courts do not hear facts or testimony or impose sentences. They're essentially the fact checkers for the trial courts. Appellate courts determine if the law was applied correctly. So, for example, you have a friend who is convicted of murder of another friend, which would not be good. That probably wouldn't be a great friend to have. But let's say there was some juror misconduct in the trial. So the jurors spoke to each other, or the juror knew one of the other individuals in the case, but neglected to tell the judge. That could be an appealable decision that the appellate courts would then overturn the trial court's decision and remand it back down to the trial court to have another trial based on that determination. Here's the court organization. You can look at this, and it's in your book on page 27 as well. You're looking at how the state courts and the federal courts kind of fan out. Now, the court structure. The U.S. courts can also be divided into two separate entities. We're looking at state courts on one side and federal courts on the other. And it's referred to as a dual court system. One court system is at the federal level. This consists of our Supreme Court at the top, our circuit courts below, and then the district courts and the U.S. magistrate. So again, you're going to have your trial or your circuit courts at the bottom, your appellate courts over that, and then the Supreme Court over the appeals courts. The other court system is established through the authority of states and consists of the state and local government. So we're obviously in California, so ours is going to have to do with California law. The federal court structure has the authority to hear cases identified by the U.S. Constitution. Article 3, Section 2 of the Constitution identifies disputes that may be heard by federal courts, including cases in which the U.S. government or one of its officers is being sued. Again, an officer of the court could be the president, it could be a senator or legislator, anyone that would be involved in our state or local government, or federal government for that matter. The federal courts also authorized to hear cases involving acts enacted by Congress. So that could be cases that are arguing a statute is unconstitutional in a particular state. It could be where two different parties are in different states. So a case would be heard in state courts or in federal courts if somebody, say, is from Nevada and sues an individual in California, because either state could have jurisdiction, or it could be heard in federal courts to make sure there's no any kind of unfair issue. The structure, again, we've already talked about, goes from the district courts to the appeals courts to then the U.S. Supreme Court, which is the supreme law of the land. The lowest component is what we call a magistrate. This was created in 1968 to alleviate the workload of district court judges. So it's essentially hearing things that are, I don't want to say lower priority, but just different priority than our district courts. It was now changed to a magistrate judge in 1990. The district courts at the federal level hear general jurisdiction cases. Most criminal and civil cases are tried and disposed in the district courts. 85% of the cases are civil, 15% are criminal. And there are 94 district courts in the U.S. At the federal level, they are basically intermediate appellate courts that then make the determination on the trial courts, just as we explained earlier with the state courts. The appeals courts in federal are going to look at the decisions by the district courts and make sure that the law was applied correctly. There are 13 courts of appeal. 12 of these courts have jurisdiction over specific geographical areas. The number of judges in each circuit is determined by sheer volume of cases, and it's a 3-panel judge at the appeals level. On rare occasions, a case may be heard what we call in banc, when the entire aggregate of judges in the circuit hears and decides the case on appeal. Appeals heard in banc involve important constitutional issues, and input from larger number of judges is deemed important. It's essentially trying to stop it before it gets to the U.S. Supreme Court, since they only hear a very small minority of cases. And then you see how we're broken up into different circuits. Here in California, we're in the 9th Circuit, and that expands all the way up through Oregon, Idaho, Nevada, and in through Arizona. The U.S. Supreme Court is the last court in that step of the federal level. Article 3 of Section 1 of the Constitution states that the Supreme Court has original and exclusive jurisdiction over all actions against ambassadors or public ministers of foreign states and all controversies between two or more states. Marbury versus Madison is a very important case. It was decided in 1803, and the most important decision in judicial review for the Supreme Court. This case was a political conflict between Federalists and Anti-Federalists. It is talked about in your book, specifically at page 31, and it talks about the idea of judicial review, establishing the power of the U.S. Court to review and determine the constitutionality of acts of Congress and the executive branch. Now, the executive branch is the president. So how does a case get to the Supreme Court? Well, we have what we call, you could go all the way through from the trial courts or the circuit courts, and then you could go all the way up and attempt to get on the docket. The judges must accept to hear the case. Or you can do what's called a writ of certiorari. This is an order issued by the lower courts to send the record up for review. The U.S. Supreme Court judges look at that docket and then make the determination if they would like to hear the case. Studying the American courts would be relatively easy if we didn't look at the state court organization. You must, in fact, add the 50 state systems and look at each one of them individually. The organization and function of the 50 different state court structures are very diverse and complex. If you look at your book on page figure 2.4, which is actually on page 34 and 35, it's going to try to explain to you what most states have. It doesn't necessarily cover all states, but California, for the most part, follows that particular diagram. We're in general, we have 4-tiered court structure. We have limited jurisdiction, general jurisdiction, appeals courts, and then what they call the court of last resort, or the California Supreme Court. Now, I'm going to talk specifically about California court structure. That doesn't necessarily mean it's going to be the same for Nevada, Arizona, Delaware, but I think it's imperative that since you live in California, you understand our specific court structure, and probably some of you have actually had interactions with our court structure, whether it be on the criminal side, the civil side, even as little as getting a speeding ticket could potentially put you in the court system. So a court of limited jurisdiction varies greatly between the states. Here we have limited jurisdiction courts that may hear traffic violations, minor civil cases like small claims, and infractions. Courts of limited jurisdiction are about 80% of the total number of state cases. Also, it could be something like family law or social security law. Courts of limited jurisdiction have the highest caseloads in our nation. They dispose of 50% of all the cases brought in state courts. And then we have general jurisdiction. This is what you think about when you think of trial courts. So they could be criminal and civil cases, and they hear a gamut of our penal code. And then 11 states and Washington, D.C. do not have intermediate court of appeals. Here in California, we do. And your limited jurisdiction or your general jurisdiction courts would then be heard by a 3-panel appellate court. Lastly, it's the court of last resort, or the Supreme Court. And in California, we have the California Supreme Court, which basically hears cases again if they are requested on the docket and up from the appellate courts. Oklahoma and Texas are unique. They have 2 courts of last resort, one for civil cases and the other for criminal cases. And that's it for Chapter 2. Email me with any questions, concerns, or comments about your assignments for this week.